has undoubtedly, because it's part of the executive of any state, a political role. And if it decides to apply for the extradition of Mr. Assange because it deplores his politics and in an avowedly political move makes an application for his extradition, that would have no judicial context. If, on the other hand, as is commonly a feature, the Ministry of Justice has, as part of its remit, the responsibility for allocating people to prisons and, in cases where they don't go into custody immediately upon conviction, determining the day upon which they should start their sentence and where they should start it, there often will be part of the Ministry of Justice that is responsible for saying, prisoner A, you've been convicted of this crime, you must report to this prison on that day in order to start your sentence. And if he doesn't turn up, often it will be that ministry that will issue an order for his detention in order to give effect to that prison sentence. Now there, one can readily see that that part of the Ministry of Justice is playing a direct role in the administration of justice in ensuring the execution of sentences passed by the court. So one does need to look very carefully at the context and determine whether or not the decision to seek arrest or to seek extradition is being taken in the context of the due administration of justice, or whether it's being taken in some other guise or for some other purpose.
But the application for extradition or surrender is in relation to a specified offence, is it not?
It is, or for a specified conviction. Yes.
Well, that will always be associated with the administration of justice, then, will it not?
Not necessarily, my lord. If, for example, one was able to say of a particular body that the application was being made not for the purposes of the administration of justice, but not where there was any domestic power vested in that body to perform a function with the administration of justice, but merely for some non-legal purpose, then you would be able to challenge it. But and I accept it may mean that it, in fact, provided the domestic law vests a function in connection with the administration of justice in a body, it doesn't really matter who that body is. It could be part of the Ministry of Justice, it could be a police board, or it could be a prosecutor.
I'm sorry, no, please continue.
And in my submission, that there's nothing in the suggested need for impartiality that would do violence to the proposition that nevertheless the person is still protected in relation to all their fundamental rights, because firstly, under the framework decision, as I will show this court, there is always a requirement for there to be an underlying domestic order justifying the process that is issued as part of the European arrest warrant. So, for example, in accusation cases, there is always a requirement under Article 8 of the framework decision to provide details of the underlying domestic judicial decision justifying the domestic process, or the conviction justifying the domestic process. So, firstly, in any case where the EAW is issued by somebody who might be regarded as a party, there is a requirement for a prior valid domestic judicial decision, either by way of conviction or order. And secondly, so far as the Article 5 rights with which Miss Rose is so concerned, there is also a requirement under both the framework decision and under the Act, once the person is arrested, for his rights under 5.3 and 5.4 to be respected. Under 5.3, there is an obligation under the framework decision and under the Act for him to be brought to court, and for the legality of detention and the need for continued detention to be considered. And in addition, there is the requirement thereafter, in terms of Article 5.4, for a court to assess the legality of his detention. So not only does the Act and the framework decision contain within it clear indications that fundamental rights are to be protected, but it is also, in my submission, perfectly consistent with the process of extradition both before the framework decision and after it, that the core decision, should this person be arrested and should we seek his extradition, is capable of being taken by someone who is a party, is normally taken by someone who is a party, and...
Not in this country.
Well, my lord...
For a European arrest warrant?
For European arrest warrant, no, but as a matter of history, the request for two things. Firstly, a European arrest warrant can only be applied for where the CPS or a designated public prosecutor makes the application. There's no power in anyone else to make the application to the court, which may issue the EAW. So there has to be a prior prosecutorial decision before we can issue an EAW. After that, the matter goes to one of the designated courts, and the court is indeed the body that issues the warrant formally. But it requires a decision by a prosecutor to initiate that process.
Obviously got to set the thing in train.
Yes.
It will be required forever. I mean, it's always going to be a prosecuting agency or the police that takes the decision, as you pointed out.
Yes.
But as my lord points out, here you have the added requirement of the perceived necessary added safeguard of going to a court.
As I think at least one of the justices pointed out, in this country and in the Republic of Ireland, the tradition has always been that any warrant of arrest is a document that is, at least in modern times, a document issued by the court.
Yes.
As compared to that, throughout the continent, as you've seen from the countries that have made designations under Article 6 of the framework decision, and this is not a modern phenomenon, this is the way they've always operated. At least 8 of the countries who've made designations are countries in which only a prosecutor will issue arrest warrants. And in those circumstances, it's very difficult to